Okay, everybody, so thank you for coming out to the next, just a quick announcement for anyone who walked in recently. Beer, soda, wine, help yourselves. Don't, whenever you want something, just get up and grab it. Thank you all for coming to the next installment of our music group. We have kind of another special format tonight. For those of you who are new or don't know, Alex, Darshan, and I, we're all working on our own music startup, which we talked about before. And in doing so, we immediately found that one of I would say the biggest challenge to any music-related startup, at least for what we're trying to go for, are legal issues. And we had no idea that was even a problem. Found out that it's a not a problem, but it's just a big hurdle that a lot of startups, a lot of music-related businesses have to deal with and make sure that they're in the clear. And so we were fortunate enough to meet an awesome attorney ourselves who introduced us to Adam. And so we had the idea a long time ago of doing kind of more of an educational session for anyone who's interested in music-related startups to kind of hear it from the attorney's point of view, things you should look out for, common pitfalls, and just a general education on the legal side of music. So, and also Adam is just a member of the group who had participated in a couple of the events and just volunteered and said, I'd love to talk to the group and educate. So with no further ado, here's Adam.
Should I move? Because I'm kind of blocking.
I got that one too.
Yeah, that's over here.
All right, well, look at that screen. So my name's Adam, and I do music entertainment law and just general IP law. And I also represent startups in licensing things like music licensing. So this presentation is adapted from something that I did on Friday when I spoke to a group of law school students. So if it's too heavy-handed or too much hardcore law, we can address that in the questions. And I'm happy to address questions as we go, or you can wait till the end and see if I cover what you were going to ask anyway. So, but if you have a burning question, just let me know.
Is that music bothering you? We can turn it off.
I think it's better to have it off, but yeah.
For whatever reason, the TVs are we'll just turn it off through the iTunes.
He needs it though.
Maybe for inspiration.
Yeah, well, I do need the...
Oh, but you'll still hear your sound. If you have any sound, you should be able to still hear it.
All right. Okay. So, so the first thing that I want to cover are what the rights at stake are and who are the rights holders. Because anytime you want to use music, it's really important to know these things before you get going. Because if you use music without the right authorizations, you can find yourself in some pretty hot water and subject to some serious liability. So initially, what I want to bring to your attention is that there are separate copyrights in musical compositions and sound recordings, and that's really critical. This is in fact, it's a major source of confusion, even among people in the music industry. So you can talk to artists, songwriters, publishers, even managers who are heavily invested in artists' career, and they don't understand that there is this distinction between the musical composition, which is the song, so the lyrics and the music, versus the recording of that song, and that's the sound recording. So just keep that in mind as we go through the presentation here. So again, musical compositions, I'm going to refer to these typically as songs, and that's like the underlying music and lyrics that happen to be recorded. For musical compositions, there is a general right of public performance, and typically these rights of public performance are administered by what are called performing rights organizations, and you've probably heard of them working in this field. In the US, we've got ASCAP, BMI, and CSAC. For sound recordings, some people refer to these as masters. I'm going to typically refer to them as sound recordings to keep it nice and clear. In the US, sound recordings did not get federal copyright protection until 1972. In fact, every recording prior to February 15th of 1972 is not protected under US federal copyright law. And the reason I've starred federal is because there may be some protection for sound recordings that were fixed prior to February 15th of 1972. But if at all, they're protected by what we refer to as common law. So that's like state judge-made law or state statute in some cases. So sound recordings are typically owned by a record label, and here again, if you have any experience in the music business, typically a recording artist is going to sign a deal with a recording label, and in the agreement, in the recording agreement, the recording artist is going to agree to either assign the rights in the recordings, or they're going to be considered what's called a work made for hire for various reasons that I won't go into here. Until 95, so federal protection for copyright and sound recordings in 72, but until 95, there was no public performance right for sound recordings. In 95, the US enacted a law, and now there's a limited public performance right for sound recordings, and that's to perform the copyrighted work publicly by means of a digital audio transmission. And I've underlined digital audio transmission because I want to use that to distinguish between the compositions, which have a general right of public performance, and the sound recordings, which only have a very limited public performance right when it comes to digital audio transmission. And the difference can be heard every time you get in the car and listen to the radio, as long as you're listening to a terrestrial radio station. To perform the works over the air, over the terrestrial radio stations, the only license that's required is a license to perform the songs, the musical compositions. There's no requirement to obtain the rights to perform the sound recordings over the air, over terrestrial radio. Okay, so what that means is that the sound recording copyright owners don't get paid every time it's played on the radio, terrestrial radio. We are one of a very small group of countries in the world that don't have a general public performance right for sound recordings. In fact, the only one that comes to mind that also doesn't give a general public performance right for sound recordings is North Korea. So you can see we're a very small and unfortunate class. At least if you're a recording artist, it's not a good, it's not the greatest place to be, in the sense that you're not getting money from those performances on the radio. So who are the players in music streaming, and what are their roles? The first thing I want to talk about is the services. And I'm going to make a distinction in my presentation between interactive, or what I'll refer to maybe as on-demand, versus non-interactive, and maybe referred to as webcasters or internet radio. So I've listed a few examples here. When I think of the two more significant players based on these distinctions, I think of Spotify and Pandora. YouTube is also obviously a very significant service. The reason I've started and sort of highlighted it is because it's visual, it's audio visual, so it's not just audio. So for the most part, in the beginning part of this presentation, we're going to talk about audio only, and then towards the end, we're going to talk about YouTube and some other audio visual stuff. And by the way, some of these services offer both interactive and non-interactive versions, but again, I'm going to try to focus on what I think of as their sort of core product for now. So what rights do they need? Well, streaming music implicates at least the public performance rights in the musical compositions and the sound recordings. So both non-interactive and interactive services are required to obtain the licenses to perform both the musical compositions and the sound recordings. The question of how they get these rights depends on the type of service at issue. So non-interactive services like Pandora can obtain what we call statutory licenses. And what this is actually a mechanism that's set in place in the copyright laws of the United States, whereby basically a non-interactive service pays into the system, and the money is received by a particular party that we'll go over later, and then distributed by that party to certain people that have a part in the recording at issue. Interactive services operate differently. They have to obtain licenses directly from the rights holders. So what this means is that Spotify has to approach the major labels and any independent that's not affiliated with the majors to obtain the rights to publicly perform the sound recordings on their service. So that's the significant difference between interactive and non-interactive when it comes to the requirements to, the way in which they obtain the licenses to do what they do. So how are the statutory rates determined? So every 5 years, this panel of ALJs, which is administrative law judges, come up with, they're called the Copyright Royalty Board, and they determine statutory rates for internet radio royalties. These are the amount of royalties that are paid by the webcasters for the non-interactive streaming of sound recordings. We're currently in a period of 2011 to 2015, and the next period will cover the next 5 years, which is 2016 to 2020. And so every 5 years, this panel, they hold proceedings, they invite evidence, and they have hearings, and they have witnesses, and they try to figure out what are the rates that they're going to set for the next 5 years for non-interactive services. And they come up with a bunch of different numbers. We're not going to go into all the numbers tonight. I'm going to show you at least one of the numbers. But different services get different numbers. And we'll go over Pandora's in particular, so you get an idea of that. So who gets the proceeds? So like I said, the money is paid from the service, from Pandora, and it goes to this group called Sound Exchange. Sound Exchange collects all the money for the non-interactive service fees, and they distribute it according to what the statute says. The statute says that 50% of the money for each performance goes to the sound recording copyright owners, which are typically the labels. 45% goes to the featured performing artists on that recording, and the remaining 5% is split between the non-featured vocalists and the non-featured musicians on the track. And that money actually goes to the unions that those people are members of. The proceeds from the interactive licenses are determined by artist recording agreements. So what this means is that when Spotify enters into agreements with the various labels, Spotify pays the labels, and the extent to which the artist participates in that money is determined exclusively by the recording agreement between the recording artist and the recording label. So let me give you an idea of practically what that means. If you work with artists, you know that a lot of times an artist will be in an unrecouped position vis-a-vis their label. So what that means is that the label has advanced some money to the artist, and they are taking sales of records or whatever income they receive as a result of the sales of the records, and they're sort of applying it towards that negative balance. So when Spotify pays the label, and the band is in a negative or an unrecouped position vis-a-vis the label, the likelihood is the artist is not seeing that money. Okay, it's being applied to recoup the amount to which the artist is unrecouped, but it's not actually coming to the artist. The difference is, in the case of a non-interactive stream, that Sound Exchange is statutorily required to pay the artist, no matter whether the artist is in an unrecouped position vis-a-vis their label or not. So the benefit for the artist when it comes to non-interactive streams is that the artist can start seeing money faster, even though they may be in an unrecouped position. Okay, so here's where we get to... Yep.
Just with Sound Exchange, is Sound Exchange like private chartered, or is it governmental?
It's governmental.
Okay.
But it has some affiliation with the labels as well. And there are issues that people sort of think, well, you guys are sort of in it for reasons that may not be. There may be conflicts of interest there. And they've been accused of that as well. So here are the real nuts and bolts of maybe what people are interested in, at least artists want to know, well, what am I getting paid for all this stuff? So before we go into some of the some of the rates. In case you don't know, we're talking about fractions of a penny here, okay, on a per stream basis. The only question is, I guess, how much of a fraction? And so artists tend to have a negative opinion about streaming, or some artists do, because they look at it and say, it takes forever to make $1. It takes so many streams to make $1. I'm losing, I'm potentially losing sales of records because people are streaming. So why should I subject myself to this? So let's get into some of the rates here. So Pandora pays an annual fee of $25,000. This is in 2014, by the way. And if I hadn't already said this, if you guys want this slideshow, I'm happy to send it to anybody who wants it. Okay, so yeah, no need to worry about it as we go, but if you want it, you can have it. So Pandora pays an annual minimum fee of $25,000, not a whole lot of money, but they pay also for what are called non-subscription transmissions, a greater of 25% of gross revenues, or 0.13 of a penny per performance, or for subscription syndicated bundled transmissions, 0.23 of a penny per performance. Okay, and this by the way, comes from Sound Exchange website. So for Spotify, now keep in mind again that this is not public information. So these deals are struck between Spotify and the labels. But Spotify has come out because I think they've received a significant amount of criticism because of a lack of transparency, and tried to be a little bit more transparent and come up with something that they can tell people. So this is what they say on their website, is that they pay an average per stream payout to rights holders of between 0.6 of a cent and 0.84 of a cent per stream. It's not really clear from Spotify's website whether that is everything, which is to say whether they're paying for both the sound recording performance rights and the public performance rights, the musical composition, as well as some of the other rights that they're required to get, or whether that's just for the sound recording component of it. It's not clear from their website. But this is at least some information that Spotify has been gracious enough to share with us. So we've been talking about the sound recording copyright performance rights. Now we're going to talk a little bit about the musical compositions. So both non-interactive and interactive must obtain licenses to perform the musical compositions, but there's no statutory license for the musical compositions. So you might think that it's a freer exchange, it's a market exchange. Well, it's not exactly. So I mentioned earlier that the performing rights organizations, ASCAP, BMI, and CSAC, administer the public performance rights for the musical compositions. But ASCAP and BMI are subject to antitrust review and antitrust consent decrees. And what this means is that unless they can establish rates through negotiation, the rates are determined by what are called rate courts. And in this case, it's the U.S. District Court for the Southern District of New York. So ASCAP by law is required to give a license to anyone who comes. Okay, so Pandora, Spotify, they say, we would like a license to perform all of the works in your catalog. And ASCAP is required to give them a license. The rates are scrutinized by a rate court, and so it can't just be whatever ASCAP feels they can charge. They're actually constrained in a very significant way by this rate court. CSAC I've starred because CSAC is not actually currently under antitrust scrutiny, although there's some effort to try to get them under the same scrutiny as ASCAP and BMI. So here's another number for you. What do the streaming services pay songwriters? So this depends on the service, but according to ASCAP's calculations, and this is echoed by other people in the industry, every 1,000 plays of a song on Pandora is worth about 8 cents in performance rights. So we're talking about 8 thousandths of a cent per stream. Okay? So what does that really mean? Well, you get to situations like this where, forgive the artist because I know it's not exactly the most popular artist, but she has written quite a few songs and people listen to her for whatever reason. So she's been streamed, at least she says, over 4 million times, and she earned $114.11. Okay, so going back to what I was saying earlier, both recording artists and songwriters and labels and people who are not making money directly from Spotify question whether it is worth it. If it cuts into sales, and you can sort of divide it out, 114, let's say generously, you could get 10 CDs out of that. So, if it's cutting in, or 10 downloads, let's say, full album downloads. So I think the money that would be coming to her, to Bette Midler, might be significantly higher. Now, of course, it's a little difficult to understand what she's saying here exactly. She seems to be suggesting that she's only talking about the musical compositions, but you just get an idea of how much money we're talking about here. So, thus far we've been talking about audio only, and I know a lot of you guys may have endeavors in audiovisual, so I want to get into some of that, into some of those areas too. So what do we need to use music in AV material and in video? So just to bring you back, just remember there's 2 separate copyrights. So just in the case of an audio-only performance, the audiovisual performance requires a synchronization license to record the musical composition in time relation to the visuals, and what's called, or what's referred to as a master use license to use the sound recording. And in the United States, there are no compulsory or statutory license for these rights. So these are all free market transactions. So if you've ever dealt with a publishing company and you want to obtain the rights to sync or synchronize a song in the publisher's catalog, the publisher can freely say no. There's no rate court. There's no statutory license. They can just say no. We don't want to do it. I can think of the Stones and Martin Scorsese and things like that. They don't license. Well, it used to be that the Stones wouldn't license their music to anybody but him. I think it's changed somewhat over the years, but they can say no. We don't want it in commercials. We don't want it in other movies. We're only going to use music in your movies. Okay. So let's talk a little bit about the Dmca. So you may have heard of the Dmca. What the Dmca established was what we refer to as a safe harbor from copyright infringement liability for service providers, and I've put this in quotation because it's a defined term in the statute. For example, YouTube has been considered a service provider for information residing on systems or networks at the direction of their users. So this is the typical YouTube situation where someone with a video wants to put it up on YouTube. YouTube doesn't have any control over what that person puts up there. So the reasoning is YouTube needs to operate. We need to provide a way that YouTube can operate and not suffer the really crippling effects of copyright infringement liability. So how do we do that? Well, we set up the system whereby owners of copyrights can notify the service provider, so in this case YouTube, and say, hey, we own this work, it's being infringed here, and you need to act to take it down. And it's technically called a notice of claimed infringement. People refer to it as a notice and takedown. You may have heard of that before. And to fall within the safe harbor, YouTube is required to expeditiously remove or disable access to the material that is claimed to be infringing or to be the subject of infringing activity. And this is only one of a number of requirements that they have to fulfill, but this is one that I wanted to highlight because if you're representing, or if you are a musician or if you're a sound recording copyright owner for that matter, or a publisher who happens to own rights in the songs, this is a significant tool that you can use to require the service provider, YouTube for example, to remove and disable access to the infringing content.
In this case, is YouTube liable for the 600ths of a penny or whatever for each play before they take it down? So if it's played 1,000 times before they receive the notice or while they're taking it down, do they owe that money to the artist, or do they put?
They are. All the Dmca does is exempt them from liability. I shouldn't say it exempts them. It makes it so that they are not liable for monetary damages. Whether they will pay for what they didn't see beforehand, it's not really addressed in the statute. But because they are not required to obtain a license and they are not liable, there's no money that's owed. Does that make sense? Does that answer your question?
Yeah.
Okay. Okay, so I want to address Content ID because this is another way that YouTube has, some might say proactively, although some others might say they were required to do it based on what they saw as the developments in the law to combat tons of massive infringement that was occurring on their site. And what Content ID, everybody knows what Content ID is here, or should I just go through it? Okay, so Content ID, the way it works, and this is a YouTube program. So copyright owners, for example, the record labels, they submit audio files to YouTube. And every time a new video is uploaded to YouTube, YouTube scans the video against this storehouse of content and figures out whether it's owned by, whether the audio in that video is owned by one of these rights holders. And if it is, the rights holder gets a notification and gets to decide what happens. Actually, I believe we might get notifications, but they also have pre-approved sort of ways of going about doing it. So it's not that they get, they may get thousands of notices a day. So the understanding is they have pre-approved ways that they're going to deal with this. And one of the ways that they can deal with it is by monetizing the video by running ads. Okay, I'm sure you've all seen it. I'm sure you've all gone on YouTube, watched the video, and before or somewhere within the video, there's an ad. Okay.
Is that Content ID matching the reason that a lot of the time, if people upload the clips from a show or something, they'll mirror image it so that it doesn't match when it goes up, or is that completely unrelated? Do you know what I'm talking about? If they have a scene from an episode of a sitcom or something, a lot of the time everything will left and right flip when people upload them. I always wonder why they do that. Maybe it was.
No, I can't answer that. So you're saying so they actually flop it, like it's not.
Yeah, I don't know how it happens or why people uploading do it, but a lot of the time if it's copyrighted material, I've noticed that episodes of TV shows, so the characters are all facing the wrong way. It's like they mirror image the video that they're uploading.
It's possible that they're trying to put it up without being caught, without getting it taken down. Mm-hmm. Now, I'm really talking about, so my examples are really geared towards like sound recordings, but I know that like Fox would use Content ID, and I'm pretty certain that they're very careful about Simpsons episodes. Now, whether that flopping really works or not, I mean, sooner or later it's going to be taken down. Somebody's going to figure it out. So I don't know, but I believe that they would use Content ID in that situation as well. So, does anybody use Twitch here? Anybody familiar with the site Twitch? Okay. So Twitch has. Folks, for those of you who don't know, Twitch is it's kind of like a gaming platform. You can watch gamers. Do you use it a lot?
Not frequently, no.
Okay.
Mostly, I got into that Twitch plays Pokemon phenomenon.
So you can watch gamers play the games, and people have their own channels, and they become. It's kind of like they get followings, like people on YouTube have channels and they get followings. So. It's a huge, it's before like 2 months ago, I had never heard of it, but it is an enormous site, and they use more bandwidth than like any other site besides like YouTube, and I guess Netflix also is a huge user. But
how sad is it that we're so lazy now that we can't even play our own games? We have to watch.
Yeah. So Twitch has a more significant mechanism to proactively remove copyright material. And by the way, Twitch, they have videos, like pre-recorded videos, but they also do live streams. And this happened just recently, so I don't have much to say about Audio Magic, except to say that my understanding is that it scans the videos, and again, not the live streams, to find copyrighted music. And if a violation is found, 30 minutes surrounding the section that has the copyrighted material is actually muted. So for someone who has a channel, and I'm not sure what they call one on Twitch, but something akin to a channel that you might find on YouTube, but on Twitch, if they've uploaded a video and it happens to have some portion of audio that Twitch's system, Twitch's Audio Magic system deems as infringing, it will mute a very significant portion. That's 30 minutes. So again, this is kind of a recent thing, and I don't have any good examples here, but I did want to tip you to Twitch and Audio Magic. So that's it, but I wanted to do some examples to give you an idea of what I'm talking about, at least in the YouTube arena.
Turn up the volume with the remote.
Okay. I have to refresh so it gets the ad. Is that cool? Or?
You just refresh the mode.
Oh,
Go back
I didn't mean
into
to go.
the presentation.
How do you reset?
Go to the bottom.
Oh no, I wanted to refresh Chrome, so because I think we've already gone to it, so the ad is gone. That's the problem.
I'm not sure.
Okay, so what was supposed to happen here is that you were going to see an ad. Okay, so I could show you an example where content ID may have been at play. I don't believe this was uploaded by anybody who was authorized to do it, but rather I think that it was subject to content ID. And like I said, there should have been an ad that ran right before it. I'm pretty certain that all of you are familiar, probably all on YouTube and seen the ads. But here's an example where, a recording is just put up there with still images, and I believe, the likelihood is, and I don't know for certain, but the copyright owner of the sound recording, as well as maybe the song, was using content ID to monetize the performance on YouTube.
So is that more for the ad or only to the artist, or to the artist and the uploader?
Actually, it's possible that none of it goes directly to the artist. I'm sorry, is that it? The sound recording copyright owner, who may be the label, the money might some of that money might go to label, some of it stays with YouTube, some of it might go to the owner or the administrator of the musical composition. But that money is going to filter down, if it ever does, per the terms of the respective recording agreements and publishing agreements that the songwriters and artists have with those companies. Okay. Okay, so here's another example.
Blinded with the chancer, we had oysters and dry lancers, and the check went in right. We went.
Okay, so the reason I wanted to use this example is because here, so there's no ad before it, and there wasn't when I first clicked on it either. I don't believe that anybody's Monetizing is, and I don't know that content ID is necessarily not at play, because I believe that one of the options for content ID is to leave it the way it is. So it's quite possible if someone uploaded this and the label found out about it and decided for whatever reason not to do anything with it. Okay, so that's that ample. Okay, here's plastic ample.
Turn the resolution down, it'll come faster.
Okay, I'm not sure.
Just on the little slope. Lower right.
All right, well, I think you get the point. So this is what YouTube is like sort of famous for, right? People, doing cover songs and uploading them. The reason I wanted to use this example is because here, the rights pertain exclusively to the musical composition. There's no sound recording. In fact, there's no sound recording to license. In this case, it may be that this group has some claim on the audiovisual, but there's no, the Steelers Wheel original recording is not required to be licensed here. The only thing that's at issue here is the musical composition. So when you're talking about people uploading covers of songs, you're typically not going to be talking about obtaining the rights for the sound recording because sound recording doesn't happen to be used. Okay, so that's all I got. Thanks for having me, and if you have any questions, fire them at me, and I'll give it a shot.
I got a question real fast. Do you have any idea how it works for DJs who mash up songs? Would that still get picked up by Content ID if it had, a bunch of different songs but it kind of mixed together? Yeah.
My understanding is that it does happen quite a bit that you have mashups that are caught because this is all sort of done by computers, and there's not a whole lot of there's virtually no oversight by humans. And so if just a little portion is caught, that may be sufficient to knock it out. And that's especially significant in the Audio Magic case because I've heard stories about, and you can read articles about how the games that were being used in the video, the music comes from the games, and the matching was done in that music. So the irony is that the music was in that game and was being played on that video, but because it was caught by that Audio Magic, it was still muted. There are similar stories in YouTube where things have been taken down and there hasn't been a real good reason for it. The Dmca, I should mention, also has a counter notice procedure. Okay, so what that allows for is what you might think of as false positives, right? So things that are taken down, and there are fair use arguments, or there are arguments that they were licensed and fully licensed to use that material. So there is a procedure to get that stuff back up, but it does take time, and you have to understand the system. There are legal requirements of information that you have to provide to YouTube, not to mention the fact that in the intervening time, the popularity of that video that may have been fully licensed is losing out on eyeballs. And that, for a lot of people, is significant because if you can imagine, you're releasing your new video on YouTube and you're putting it up and it gets cut down immediately through no fault of your own. And a day goes by and that is a very significant part of your launch, your push, and you're missing out on those viewers. So
for some of the bigger labels? Is this someone's full-time job just to receive those ID content messages and say yes, no?
So that's why I mentioned the major labels. They get inundated with these. I don't work with the major labels in this capacity, but I will say that I suspect they get inundated with these things, and they have these sort of pre-approved ways of doing it. So they say, yes, we're going to monetize everything, or we're going to monetize this stuff, or we're not going to monetize that. So, and then there may be some oversight, which is to say, periodically they might go through it and say, this isn't working for us. How can we do this better? Our artist is giving us shit. We don't want to do this anymore or our artist is giving us shit on the other side. They want to see these things up there. Their fans are getting pissed that they're not allowed to do. Like Katy Perry may say, well, my fans want to, put songs up, and I want this to happen. So the label says, even though they're in control of the recordings and their ability to do or the publisher for that matter, they're in control of the songs. They still have to be. There's still artist relations, right? They still have to be aware of what their roster is saying about what they want their music to be used for.
Jumping back to mashups, do you know how it works on Spotify when a mashup is played? There's a DJ group called the White Panda, and that's pretty much all they do is they mix songs together.
Mm-hmm.
So did they already buy those songs or were given those songs, and so that play, they're the only ones get paid, or is it they get paid and the two songs they mashed up also get paid? Do you have any idea how that would work?
Yeah, so for Spotify, you're not dealing with a UGC kind of situation. You're dealing with labels or aggregators who are entering into arrangements with Spotify. Okay, so the provider of the content, which is a funny way of saying the owner or the administrator of the content, gives the content to Spotify and promises that they've cleared all of the rights in whatever tracks they're providing. Now, mashups present a lot of different legal issues. There's questions of whether some of those samples you think of like a Girl Talk, for example. Like, do those samples require licensing or not? We can debate that. Maybe it's reserved for another time, but. The proprietor of that recording, or at least the purported proprietor of that recording, is promising to Spotify or the aggregator that they own the content and they fully license all that stuff. The money would flow from Spotify to the aggregator to the provider of the content for division amongst all the people that the provider feels is required to get paid. So taking it out of a mashup context, recording artist signs a deal with a label has a relationship with an aggregator or has a direct relationship to Spotify. Spotify pays the label, and the label pays the artist according to the terms of the recording agreement.
Makes sense.
Okay, anybody else? Yep.
Not to keep splitting the baby on this mashup aspect, sure. Is there, both from a technical perspective for all the back end side and also from a legal perspective, how much of a song, if I have a 5-second clip or a mashup of 6 5-second clips, how much of that is how much of a song is necessary for it to be recognized by the system and to be recognized by the law for licensing purposes?
Okay, I don't know. I can't answer either one of those questions. I'll tell you why. So, when it comes to Content ID, I'm not aware of the requirement. I mean, YouTube has what they have determined to be legally required, maybe, to pick up that stuff. It may or may not have any reality and basis in the law, and that's moves on to your second question. How much? Is it 5 seconds? Is it 2 seconds? What's fair use? These are things that are really very, very fact specific and are determined on a case-by-case basis. There's a multi-factor test that the court uses to determine whether fair use is at play. So it's without hearing the particular sample you're using, it's impossible for me to opine on whether it's fair use. But there's even other complexities, and there's a principle called de minimis. There may not even be enough, sufficient to rise to the level of copyright infringement. So there's a lot of questions, and I respect the question, but I don't know that I can fully answer it right now.
All right. And just one other question. The term service providers, is that mostly for something like YouTube, which almost exclusively does audio-visual, or would that apply to like WordPress, which hosts all these websites that you can embed it in, or even Facebook, where you can embed a video straight on it without necessarily going back to YouTube?
Right. So embedding presents some different legal issues. So without going too far into detail, so let's say you own a video. Okay, copyright adheres in both musical compositions, sound recordings, and audiovisual works. Okay, so imagine someone owns, Fox owns The Simpsons, right? If part of the bundle of rights that a copyright owner has is the right to reproduce the work, to distribute the work, to make derivatives of the work. When a video is embedded, there is a significant question of whether the work is actually reproduced on WordPress. Okay, so it's entirely possible that someone is embedding a link from YouTube and is not actually causing an infringement of any rights, because there isn't an independent reproduction. Okay, and the law has looked at it and said, at least in a number of cases, and said, unless the content resides on the servers of the provider, there isn't any storage, there isn't any reproduction, there isn't any infringement. Okay, does that answer your question?
I think so, but I mean, like in a case where I were to make a video and use an audio recording, and then just house it on, put it on my site so it's stored on WordPress or on Facebook, is that the same scenario as what you just said? I'm not taking I'm not taking anything off of YouTube. I'm creating it offline and then putting it on.
So you are actually uploading it onto your WordPress page.
Right, yeah.
So the Dmca safe harbor provisions apply to a lot of different types of service providers.
Okay.
In YouTube's case, I focus on the UGC side of it. It seems to me that it applies also not just in AV material, but in all sorts of, it could apply to text. Anything that you put up without their ability to sort of monitor beforehand, that would allow them to fall within the safe harbor, provided that they do, among other things, take down the stuff when they are told that that's infringing.
Got it. Thanks.
Sure.
In that, mentioned before that there's that rate board that beats every 5 years. Then you also mentioned that Spotify works out their own individual deals with big and middle and small labels. Could that board ever come in 2015 or whatever the next one is and says, now we're going to determine what the rate is for you guys, or are they hands off?
They only apply, the CRB, the Copyright Royalty Board, only applies to non-interactive services. Okay, so they could never come in and take that sphere away. That's really reserved. And really, I mean, that's a benefit. Like I was saying, the Sound Exchange pays out to artists regardless of their position regarding a recoupment vis-a-vis the label. So it's a benefit to artists to have that sort of statutory regime, even though we can, a lot of artists are question the standards that are used by the CRB. It's actually a benefit over these privately negotiated transactions because it's, number one, it's more transparent, but also, like I said, they get paid directly from Sound Exchange as opposed to waiting for the label to decide that the band is now recouped and start making money that way.
There's a question, more of a comment on some things that are in the news, and to your question about how much. Would you, I missed the beginning of the presentation, my apologies, I take it from your demeanor, you're a lawyer?
I am, yeah.
Okay.
Demeanor.
No, it's okay. I mean, it's just
radiates law.
No, it's legal precision. But I think most law comes down to your ability to defend. So you can have a copyright, a patent, or a trademark, and if you don't have the cash to defend it, it doesn't mean it gives you nothing. And so the likelihood of 2 seconds worth of music being subject to attack may well be about how much money it makes. So there have been cases, just as an interested party that I've read, where somebody had 6 bars of a particular intro, but because the tune became popular, it's now deep pockets, it's worthy of somebody's attention, and they got sued. And then if you look at, and then generally there's mitigating factors. So for example, when Ghostbusters came out, I forget the fellow that wrote the theme for that, they specifically asked for a Huey Lewis tune. Huey Lewis said no, so they had the other guy write it just like I Want a New Drug, and they stated that. They had emails and other correspondence that people could track, and he got his ass handed to him, and all the money went to Huey Lewis, or at least a fairly significant chunk. Right now, in the media is that one All About the Bass that some little girl did, but measure for measure, it's the same as a group from Korea that did it too. And they're all up in arms and have got lawyers involved. The problem is the group in Korea ripped it off from Fish. And so the bottom line is it almost doesn't matter unless somebody has the cash to attack you, because it costs money to hire freaking lawyers. But would you agree with that or not?
I mean, when you look at an infringement situation, so I'm a lawyer and I do intellectual property, including litigation on occasion. But when you look at any kind of should we go after them scenario, yeah, at the end of the day, what do they have to pay you? Because you can get a judgment, but it doesn't mean anything unless you can collect. And if they don't have money, you can't collect. So to a certain extent, I agree with you. In the copyright world, the U.S. law allows, it's permissive in the United States to register copyrighted works. The reason it's one of the reasons it's very beneficial is that you can obtain what are called statutory damages and attorney's fees. Okay, so you don't necessarily have to have, or you don't have to, there's less risk at the end, okay, because you're not only recovering your damages, but you're also recovering, in some cases, when it applies, your attorney's fees. Okay, so it makes it a little easier for a young artist who happens to have a lot of material that sounds good. It protects them from getting just blatantly ripped off a little bit more. Okay, because if a big label comes along and says, well, we're just going to use it, at least there is somewhat of a tool to go after them with the understanding that you could possibly collect your attorney's fees.
Does that only apply if you win though? That you recoup the attorney fees after?
You have to win to obtain. In fact, it works the other way. If you lose, the possibility is the defendant can obtain your attorney's fees. So you have to be in the right. And there's a lot, there's more, with everything in the law, there's a little bit more complexity to it, but there is a risk that if you lose, you're going to end up paying their attorney's fees.
Unless you work out a deal with the lawyer too. If you collect, they collect, and they're in it together, which, I've seen.
You mean a contingency?
Yeah, something like that.
Well, but you're talking about between you and your label, you and your lawyer.
Yeah.
That doesn't matter between you and their lawyer. So what I'm saying is if I sue somebody for copyright infringement and it is a totally bogus claim, right, I have to potentially pay the defendant's party's attorney's fees, which is my responsibility. So regardless of whatever, now the defendant may have had a deal with his lawyer, we won't charge you or whatever, but potentially I'm on the hook for their attorney's fees.
For user-generated content, is there any difference between whether it's done by an individual or by a company? Like an ostensibly for-profit purpose of making something, or is the usage just treated the same in either case?
For the service provider or the user?
The service provider. Or if you're the rights holder, is there a different recovery? Is there any more shelter for someone who's as an individual, or is it just kind of again a matter of discretion in terms of going after?
Well, for service providers, it's I don't believe it's addressed as to whether it's going to be an individual or a company. I think for the most part, it's understood that these are for-profit companies. We're talking about things like Google, YouTube, enormous companies, for-profit companies. If you're asking whether it depends on whether there's a difference whether the user is a company or an individual,
right?
For the service provider, it doesn't matter. Service provider, it's pretty plain in the statute. Well, I shouldn't say it's so plain in the statute. I don't believe the statute addresses whether a user is going to be an individual or a company. So what that means is that the service provider can get that safe harbor regardless of whether it happens to be a company or an individual set up. All right, guys. Well, thanks a lot for having me. And